state court findings for abused youth seeking special immigrant juvenile status. Today's webinar is presented by the U.S. Department of Justice Office on Violence Against Women and the State Justice Institute in partnership with the National Immigrant Women's Advocacy Project, NUAP, Equitas, and the California Coalition Against Sexual Assault. I am David Lee, and I'm here hosting this, and I'd like to have my colleague Versha go ahead and read the disclaimer, please. Versha?
This project was supported by grant number 2013-TAAX-K009, awarded by the Office on Violence Against Women, U.S. Department of Justice. Please note the opinions, findings, conclusions, and recommendations expressed in this program are those of the authors and do not necessarily reflect on the views of the Department of Justice, Office on Violence Against Women. This project was also developed under grant number SJI-14E234 from the State Justice Institute. The points of view expressed are those of the authors and do not necessarily represent the official position or policies of the State Justice Institute.
Thank you very much. And I'd like to just introduce several of our speakers today. I'm going to first talk a little bit about how to use the technology. You will see here on how to do this, many ways of being able to participate. We try to engage people. One way is to raise your hand. And the way that you raise your hand is you'll see above my picture, which appears on the far left. I'm changing the picture to me. It is being slow today. You can circle a little hand there and it says my status. And can everyone please raise their hand? So go ahead and raise your hand. We will be asking several times today for people to raise their hand and asking some questions and for us to learn about the experience that you have throughout here. For the audio, I will let people know to call in for the audio if they can't get it on their computer, and I am doing that now. Okay, so thank you all for doing that. There's also the text chat that many of you have already figured out how to do, and the text chat is just a way that you'll be able to communicate with this. Feel free to ask questions in the text chat. We will not be able to get to all of the questions during the web conference, and we will let you know how we will be answering those questions. There are PowerPoint slides. Those slides will be available on the NUAP website, and that will be posted later on in the web conference and in your follow-up, so you can get a copy of all of the slides and materials that we're referring to. And you are on the phone, and we don't need people to be checking in for this. And thank you, BB, for sharing that information on how to get all of the slides. If you want to be able to, you can always send a private text chat by clicking on the private tab, and you can be able to get a question. Or if you need help with technical assistance getting on this web conference, call iLink Technical Support at 800-799-4510. If you need help getting onto the web conference, contact iLink at 800-799-4500. So with this, I just want to quickly introduce some of our speakers. We have Eileen Matushik. So hi, Eileen. Can you just basically describe who you are?
Yes, certainly. I work with the United States Citizenship and Immigration Services, and I work with our Office of Policy and Strategy on SIJ-related policy guidance. Thank you for the introduction, David.
Great, thank you. And we also are joined by Commissioner Loretta Young. Can you just briefly describe yourself, Loretta Young, please?
Yes, I'm a commissioner in Delaware in Newcastle County Family Court. I've been in that position for about 16 years. I preside over several specialty courts, adult and juvenile mental health court, felony gun court. I also hear domestic violence cases, both civil and criminal. I do PFAs, and I also am assigned to juvenile criminal calendars.
Great, thank you very much. And we are also joined, as we have been for all of our NUAP web conferences, by Leslie Orloff of NUAP, and you are there with Megan Fitzgerald. So Leslie, can you introduce yourselves?
Yes, I'm Leslie Orloff. Welcome. I'm the director of the National Immigrant Women's Advocacy Project, and happy to have you here today. We're hosting this conference, and we'll be happy to provide further information on questions that may not get answered following the webinar. And Edna Yang is going to be joining us in the chat momentarily to assist. She's with American Gateways in Austin, Texas, is one of our partners under our OVW grant and our State Justice Institute grant, and will be assisting and answering questions in the chat. Megan?
Hi, this is Megan. I'm a fellow with the National Immigrant Women's Advocacy Project. As Leslie said, we'll be doing live technical assistance, but if you do have a question that we're not able to answer immediately, I'll be posting a Q&A after the webinar in the days following, and you can also contact us at this number and email directly.
Great, thank you very much. So I want to learn a little bit about who the audience is. So we want to get a sense of who is in our audience. So I'm going to put in the left-hand corner an A, B, C, or D. So look in the left-hand corner, and please check the box that best describes you. Are you A, an attorney, not in the text chat, but put it in the feedback box? B, are you a domestic violence or sexual violence advocate? C, a judge or court staff? Or D, other? And if you're another, then you can go ahead and we'll ask you to type that in. But go ahead and put this in, and I see that I still have 70 of you. Pardon?
Share the live results, please.
I'm going to share the results, and what we can see is we have 80% are lawyers in our audience today. We have another 18% who are domestic violence or sexual violence victim advocates, and we have just a very few who, judges or other court staff, and we have about 20% who are other. And if you're other, go ahead, write in the text chat what the other is. And I see we have legal interns and law students in a government agency, interpreter, intern. So thank you. A lot of interns and paralegals for the others. So we have overwhelmingly a very large audience of lawyers here. So Leslie, really helpful to get to see who's joining us today.
It looks like about 8 to 10% might be judges, so judges and court staff. So that's great. Thank you all for joining us today. Loretta?
The learning objective today, whether you are bench, bar, or court-involved agency or staff, by the end of this training, you're going to be able to better screen victims for SIJS eligibility, understand the different kinds of qualifying abuse petitions for eligibility, identify which SIJS children can be represented with OVW funding or LSC funding, address family court jurisdictional issues, and issue or obtain SIJS findings from state family courts.
So the next slide will, okay, wait, sorry. So during the webinar and after, we have a live website link to the PowerPoint presentation that includes the first portion that Commissioner Young and I will be doing, and the last portion that Commissioner Young and I will be doing. The EHS part of the presentation will only be available live, and the slides will not be available online. There is a link, however, on the slides to the materials, the really excellent materials that USCIS has prepared on this that you can get off the USCIS website, and you can see a picture here of where the materials exist on our website as well. So,
SIJS is immigration relief for children and youth who have suffered child abuse, emotional, physical, or psychological, neglect or abandonment, and these terms will be defined by your state law. A child who has been a victim of sexual violence or exploitation, a child who has been a victim of domestic violence, either direct or indirect, and a child who has suffered battering or extreme cruelty.
Okay, David, the slides are over to me. Thank you. Okay. So for all of those different kinds of abuse, there's a range of different kinds of immigration status victims may be eligible for. And I know that today we're going to be talking almost exclusively and mostly about special immigrant juvenile status, or SIJS. But I think it's important as we start to step back for a moment and understand that children and youth who are victims of the kinds of abuses that Commissioner Young was just talking about, sexual assault, child abuse, domestic violence, dating violence, fall within a number, could qualify for any number of forms of immigration relief. The ones in red in this slide are the two areas where courts and judges can be involved in officially issuing some kind of an order or signing a certification and play an active role potentially in those cases, generally once they've made a ruling finding domestic violence, dating violence, child abuse, sexual assault, stalking, etc., child abuse, neglect, or abandonment. And that which of these remedies somebody may qualify for will depend in large part on a number of factors. What kind of abuse it is, so you can see that the U visa covers a broader range of abuse than, let's say, the VAWA self-petition, which is mostly child abuse, sexual assault, and domestic violence, and stalking. And SIJS is going to cover abuse, abandonment, and neglect, when abandonment and neglect are not necessarily covered in other kinds of cases. So when you are working with a victim, since there are many of you on the phone who are advocates and attorneys, it's important to know that you want to look at all of these forms of abuse as potential for immigrant children that you may be working with. Some of them, the abuse will need to have happened generally in the United States. Others of these remedies, like asylum and SIJS, the abuse could have happened abroad. Some of them will depend on who the perpetrator is. So if the perpetrator needs to be a parent in SIJS cases, or a step-parent, in VAWA self-petitioning cases, it could be a parent, a step-parent, a spouse, former spouse, or an over 21-year-old child in an elder abuse case. So just as a footnote, we have lots of materials available on all of these on our web library, but it's important to understand that when you're working with a child, you want to think of all of these as options and figure out what may be the best for that individual child. So next, what I'd like you to do is raise your hand if you are working with an agency that receives either Office of Violence Against Women or STOP funding from the state. Can you raise your hands? We're seeing, okay, the numbers are still going up. Looks like somewhere around 40 of you, 41 of you are receiving OVW or STOP funding. Okay, David, can you lower the hands? How many of you are receiving Legal Services Corporation funding? How many of you are working for LSC-funded agencies? Again, a good number of you. There could be a lot of overlap between those two. And we're going to be describing, the reason we're asking, we're going to be talking about what LSC-funded agencies can do for children and what OVW-funded agencies and what the differences are. So there's about 17 or 18 of you that are receiving OVW or LSC money. How many of you are receiving both sources of money? Can you raise your hand? David, can you lower? Okay. Looks like, again, okay, raise your hands if you're receiving both sources of money. A smaller, looks like about 10 or 12 of you have an overlap. That's great. So we have a question and answer. We're going to use the feedback box again here. Please type or check the boxes. David, can we have the box on the bottom left? There we go. So can OVW, the question is true or false, yes or no, can OVW and LSC funded agencies represent youth seeking SIJS? If you believe the answer is yes, please check yes, or no, please check no. And what we're seeing in terms of, David, you want to report back? No? What we're seeing in terms of the feedback is about 90% of you say that you can, and 11% roughly say that you can't. And in fact, you can, with both sources of funding, represent children seeking SIJS. And we'll talk now about how you get there. So, with VAWA money or STOP money or Office of Violence Against Women money, you can represent anybody who's been a victim of dating violence, domestic violence as defined by VAWA, which includes essentially the definitions under everybody who would be covered under your state protection order statute. Victims of stalking, victims of sexual assault, but youth have to be at least 11 years old. So the limitation on representation of children from the OVW perspective has to do with the age of the child. With legal services funding, you can represent victims of domestic violence, sexual assault, human trafficking, or any U visa qualifying activity with no limitation on age at all. So you could represent even younger children than OVW grantees can. But what's important to understand is that if you look at these two lists, on the VAWA side, if you have a child, so everybody here, legal services or VAWA funding, can represent victims of child abuse. Both can because it's a subset of domestic violence. Victims of children who've suffered abandonment or neglect don't directly fall into these categories necessarily. So how do we address those? So what happens is if you receive LSC funding and you want to represent a child and the child was abandoned by their parent, let's say in the home country, can you represent them? And the way you have to analyze this, and there's a letter from LSC that we have at our web link, and that Bibi will post in the chat now, that describes this. So if you have a child, you have to find either domestic violence, sexual assault, or human trafficking or a U visa crime. U visa crimes include stalking. And so what will happen here is that you will need to, in order to represent somebody who on an abandonment or neglect SIJS case, you have to determine whether abandonment or neglect for that child would constitute extreme cruelty under the LSC adopts the immigration law definition of extreme cruelty. So you're going to look at factors like the child's age, pre-existing or aggravated conditions, and if a child was, let's say, abandoned at 6 months old, and the effect that that had on the child's life might in fact be extreme cruelty, whereas if a child was abandoned at 17 years old, it may not qualify. And that's the kind of analysis that you would need to do. So the next thing I want to address has to do with a number of you may be and will be talking about the various routes to special immigrant juvenile status. And one of them can be children arriving in this country as unaccompanied minors. And before we moved more deeply into this, want to provide some context on this. And so what happens is when a child crosses the border, and if that child is apprehended by immigration enforcement officials, the ICE will hold them they have to be screened, and they can be held for up to 48 hours, and then they have to be transferred to the Office of Refugee Resettlement at HHS. HHS will then seek a parent or another adult to come and pick up the child or to place the child with them. That there may be a parent in the country, but that they don't come if the parent doesn't show up or isn't willing to come to immigration to pick up, or to ORR to pick up the child may be placed with another guardian. That process for many children takes about a month. It can be a bit longer. And that most children actually end up with family members or with guardians in the community and are not in custody. For the children that end up in custody in ORR facilities are children where a safe place hasn't been identified, and it's a smaller proportion of children. So it's important also to note here that the legal definition of unaccompanied child are children who don't have a parent or legal guardian available to provide custody. in this context with SIJS and with unaccompanied minors, it generally means that there's not a parent available to pick the child up, and that the ORR will identify another family member. To find legal services, so to find, if you're a court and you're on this webinar and you're interested in finding out who in your community might have experience working with immigrant crime victims, immigrant survivors, and immigrant children, we've posted a link to our directory, that NUAP's directory, where we have a state-by-state directory of programs we've been able to identify that have actual experience in this. And then we also have a link to the Executive Office of Immigration Review's free legal services providers here for you. Loretta, back to you.
Always take into consideration your child's history of trauma when you are making or considering placement decisions, considering immigration options, and even when you are speaking with a child in proceedings such as custody interviews or in a criminal proceeding during the colloquy. Take into consideration the child's demeanor. Sometimes the child may seem disrespectful, may seem uninterested, but it may be a mere indicator of complex trauma. You should also take into consideration the child's trauma history when you're considering the child's mental health or physical treatment needs. If we could go to the next slide. The verdicts in on kids who have experienced primary and secondary abuse. And as you'll see, there are some citations for further reading in EndNote A. Kids are not able to comprehend or process domestic violence. They don't understand why it happens. They're not sure if it's something they did. They're not sure if it will happen again. And all of this uncertainty and unpredictability causes extreme stress to them. This extreme stress creates a potential for post-traumatic stress disorder and maladjustment. Stress disrupts the architecture of a child's developing brain.
Next slide.
Children who have experienced or witnessed abuse will manifest symptoms such as feeling powerless, this profound sense of helplessness, a sense of knowing that something bad is going to happen and feeling that there's nothing they can do to escape it or change it. They may be hypervigilant. They may have low self-esteem, which also makes them a soft target for perpetrators looking for child victims or for being drawn into their own abusive situations or relationships when they're dating or as an adult. They may manifest behavioral problems, problems in school, which are related to loss of concentration and or expulsion or suspension in connection with the aggression they are exhibiting. This can carry over into adulthood, and you will see adult criminal acts. And often you will see children and adults who were subject to high levels of stress suffer more physical health problems, and they will self-medicate with street drugs.
David, next slide. So, and what happens is what Commissioner Young is describing is part of the explanation, this vulnerability that immigrant children have and children who have been abused combine. And when we see some of the research that has come out about immigrant girls and sexual assault, what we find is that immigrant girls, by the time they reach high school, are twice as likely to have suffered sexual assault than their peers, and it's often multiple incidents of sexual assault. And so that is the result of what can happen with domestic violence and child abuse in the home. And it's important to understand also that there may be children who come over the border, let's say, who don't qualify for special immigrant juvenile status at the time they enter the country, but then end up in a placement with extended family members and end up a victim of sexual assault by their brother-in-law or by an extended family member, a cousin or a brother or an uncle, step-cousin, brother, uncle. And so it's important for those of us that are working with immigrant survivors to be regularly screening for abuse, because eligibility for SIJS may actually occur based on abuse that occurs here if the child ends up being targeted for abuse. Commissioner Young?
As can be expected, sexual abuse is devastating to a child. It causes psychological harm. It affects cognition, results in physical health deterioration, and as we discussed earlier, there are common attempts to self-medicate with alcohol or drugs.
Next slide.
And the aftermath of sexual abuse can carry into adulthood. It can even affect the next generation. As this slide indicates, there are early onsets of maladaptive sexual development, re-victimization, as Leslie was just describing, and other physical maladies, premature deliveries, early pregnancies. These individuals often experience domestic violence in their own relationships, and statistics show that offspring born to abused mothers are at an increased risk for maltreatment and overall maldevelopment.
David, can I have the podium back? Next slide, please.
There are ways to mitigate the damage caused by abuse. However, undocumented youth do not have access to all services. SIJS can result in work permit approval, access to therapeutic services, community programs, higher levels of education. These are all things that victims need to be able to heal. These services and opportunities will help individuals take their life back, increase self-esteem, and increase overall feelings of security.
And so many of the children that you are working with or that come before courts, they have options immigration options, going back to the slide that I was talking about earlier, based on either their own application or they might be included in the parent's application, and that immigrant children's best interests are often promoted when state courts issue findings regarding that the children need to apply for SIJS status in the context of a custody case, a protection order case, a child abuse and neglect case. We're hearing more about that. When they sign U-Visa certifications, and that it's also important for courts to be aware. We have whole webinars and lots of other information at our SIJ, in our State Justice Institute funded materials, because courts can, by their rulings, inadvertently cut children off from legal immigration options. And they could also, may also end up, by relying on immigration status factors as opposed to best interest factors, award custody to abusive as opposed to non-abusive parents. And so, as Commissioner Young was saying earlier, SIJS and immigration status provide pathways to work authorization, driver's license, financial aid to attend universities, and it removes the fear of deportation and provides more stability to children. So, how many of you have been involved? Please check yes or no. Have you been involved in a case where an immigrant child received SIJS findings? And that could be either a court who issued them or an advocate or attorney working with a victim who received them. And what I'm seeing is that about a little more than half of you, 57, 56%, have been involved in a case. That's great. Do we have, let's just do a hand raise for a moment. How many of you are working at courts or are judges who've issued SIJS findings? Can you raise your hand if any of you have done that? Okay, and I see that we have some judges and court staff on the line, and it looks like at least 10 or 11 of you have done this. That's fantastic. Is the state court granting the child immigration relief? Is that true or false?
Or yes or no is what we asked.
Yes or no?
Go ahead.
David.
And yes, so when a state court issues an SIJS findings, is the state court granting the child immigration relief? We have overwhelmingly a no response, as people can see. 95% is a no response. Which
is correct. The state is making state court rulings regarding that child's care and custody and needs, and that order doesn't control the outcome. It's a prerequisite where they need the findings to be able to file for SIJS, but it doesn't control the outcome. Great. So, Commissioner Young. Oh, I'm sorry. I jumped too early. We want to get an ABCD question, and so let's ask: which group of immigrants, abused, abandoned, or neglected children have you worked with or seen in your courtroom? And so, A, in the child welfare system; B, outside the child welfare system, coming to court in family law cases; C, both; or D, none of the above. And Leslie, as we can see, very even response. We have, it looks like A, actually we have only 11% in the child welfare system, but B, 38% outside the child welfare system coming through family law cases. And we have both is another 31% and 23% or none of the above. So a lot of you are seeing cases where you could potentially get SIJS orders. It sounds like almost evenly split between family court and family or child welfare court, the child welfare system. Very few of you are seeing them only in the context of the child welfare system, which is good news because the law has changed, and where before 2008 those cases were exclusively, almost exclusively brought in the child welfare system, they really are being brought outside of that system today. The U.S. Department of Homeland Security has a number of functions that are related not to removing only removing undocumented immigrants, but providing humanitarian protections for immigrant crime victims and children. And so what we're going to be doing today is talking really about one of the several forms of humanitarian relief that are available to immigrant crime victims and immigrant children, which are special immigrant juvenile status. And in the web library, we have bench cards on some of the DHS enforcement priorities, which are designed to ensure that the Department of Homeland Security doesn't waste its enforcement resources on going after immigrant child abuse victims, immigrant children that have been abused or abandoned, and immigrant victims of domestic violence, sexual assault, or human trafficking. And as you might imagine, there are a world of perpetrators of these kinds of crimes out there that are very interested in trying to get Department of Homeland Security to use its enforcement authority to remove immigrant crime victims and kids who might be witnesses against them in criminal investigations and prosecutions.
So the special immigrant juvenile status is unique among immigration remedies. Because the application process requires this involvement of a juvenile state court, whereas applicants for other immigration remedies proceed solely before the federal authorities. A child seeking SIJS must first ask an appropriate state court in the state where the child is living to make certain findings. And these findings involve determinations that, among other things, whether reunification with one or both parents is viable due to abuse, neglect, abandonment, or similar grounds under state law. And this requirement of this family court order reflects Congress's reasoning that a state court, a family court, is best suited to make these findings relating to custody and child protection.
Great. And so one of the things I think that is important to remember is that those best interest factors are by state. And for those of you that are working in different states or may not be in family court regularly, we are producing a chart that should be ready in the next month or so, within the month, I think, where you'll be able to look up the factors and see what the best interest factors are by state and make it easier for those of you that are going into family court to be aware of what the courts are going to be expecting to look at. So we're going to involve you a little bit more and talk, have you guys vote on some true or false questions. So David has the box again up at the bottom left of your screen, and so we're going to do some true and false. So the first question is, only children in foster care can receive SIJS findings. True or false? How many of you think that's false? Have everybody voted?
And you can see, Leslie, that people are saying, almost all are saying it is false. It is not true.
That's correct. It is false. That you can bring, you can get SIJS findings in other kinds of family court proceedings. Second one, can you clear those, David? We'll start again. Courts can issue SIJS findings when the court places an immigrant child in the custody or care of a battered immigrant parent, meaning the non-abusive parent who's also a battered immigrant. True or false?
And Leslie, as you can see, we are mainly getting yes, true, 83, 84, 85%.
That is true. One of the things that we did as part of OWA 2005 is, or actually no, this was TVPRA of 2008, was to make sure that a battered immigrant parent, if the abuse happened in the United States often, even when it happened abroad, but if it happened, there were a lot of cases where the abuse happened in the United States, the child fled with their immigrant mother and then couldn't apply for SIJS, and now that's no longer true. They can apply even if they're living with a protective parent in the context of a custody case or permanent protection order case, etc. Another yes-no question. Can the court make SIJS findings when child custody, placement, or care of a child is addressed in a custody or paternity protection order or guardianship case? True or false? A court can make findings in one of those kinds of proceedings when they're addressing placement or custody of care or another state function.
And Leslie, as you can see, 97% are saying yes, true.
That is true.
The special immigrant juvenile status, the eligibility requirements, they have to be under age 21 for federal purposes, and that filing will freeze them. But you have to keep in mind that you have to still keep the state court jurisdiction. So you have to be mindful that your child could age out. When you're looking at also proving abused, abandoned, or neglected, you have to look to your state law for definitions. And when we're talking about using state court findings as evidence, we are mindful that in different states, the courts may be split, such as the state of Oregon. We know that they're structured in a way that the juvenile court hears delinquency, such as juvenile drug court and criminal offenses, dependency, TPRs, emancipation matters, and then the family court hears matters of dissolution, such as divorce, separation, custody, visitation, and child support. The SIJS regulations define juvenile court as a court located in the United States having jurisdiction under state law to make judicial determinations about the custody and care of juveniles. So when we're saying state court, or if I'm saying family court, it's a rather broad term. In many states, this could mean a traditional juvenile court, family court, or the family division of a court of general jurisdiction. Special immigrant juvenile status eligibility requirements. If we dissect this slide a little bit, when you're talking about state court findings required as evidence for SIJS, what does this mean? That means you need to get an order from a family court, from the juvenile court, that contains the necessary factual and legal determinations. And during this presentation, I will refer to that as the predicate order. When you are looking at the child, the other factors you need to prove: abused, abandoned, neglected. You need to look at your statutory definition, or you can also argue similar basis. When you're looking at whether or not it's in a child's best interest to be returned to the home country, how do you prove that? There's no federal guidance. This is state law territory, so you may need to document this child's situation, more of a weighing. Look at the situation if the child were to remain here, and what the situation may be if the child will return to a parent in another country or to the child's home country. All the following children's scenarios are potentially eligible for SIJS. A minor who is abandoned, abused, or neglected, and the maltreatment occurred in the U.S. or in the home country, and the child is living in the U.S. now with a non-abusive parent, guardian, adopted parent. Why do these particular scenarios set off the bell? Because there may be an order issued deciding a change in placement or custody, the issue of reunification, whether or not it's viable. So these are cases where you have an opportunity to prove the factors necessary.
So the congressional goals in involving state courts in SIJS cases was to rely on the expertise of the state courts and to make the determinations that state courts routinely make regarding care and custody of children, and they recognize that there are all kinds of different contexts in family court where courts are involved in placements, custody determinations, orders regarding how to care for a child, and adjudicating the findings of abuse, abandonment, and neglect that state courts have much more expertise at than do the federal government. Commissioner Young?
Yes, that's correct. The factual findings of abuse, abandonment, and neglect that is left to family court's expertise in child welfare and considerations under state law. It's important that that state court order, be inclusive of all the facts and findings and clearly state at a bare minimum the facts of the case, how jurisdiction is conferred, factual findings, and conclusions of law under your own state law. And I certainly advocate that in your motion or petition, plead with particularity. Cite state statutes and case law to guide the court who may or may not be familiar with this issue.
Commissioner Young, as a court, when this comes to you, what flexibility do courts have or judges have in terms of making those findings? Because some of the counsel that may come before the court might not be as sophisticated or as knowledgeable about these proceedings.
It's always in the court's authority to do what is best for the children that appear before it. So there are lots of issues that bring into focus what's best for a child. One of the things, certainly if the court comes across an SIJS issue, it is well within its authority to bring that to counsel's attention. Certainly you can ask questions of counsel. You can ask counsel if they're aware of this issue. If you still feel that they may not be on track, you can certainly ask them to submit a memorandum of law so that it may take them a little further into that territory. Perhaps they'll recognize some of the more important issues.
And then what happens is once the state court makes its determinations, the Department of Homeland Security adjudicators will then review the application, look to see that the court provided some specificity of that, they made findings of fact that this child has been abused, findings of fact that they've been neglected. There may be some cases where, where they can see that the court considered and made a ruling, in which case the Department of Homeland Security isn't going to necessarily go behind that ruling, but they're going to want to verify that there's a state court purpose related to child protection, child welfare, the child's best interest, that was the purpose for that order, and that it wasn't solely for immigration purposes. Commissioner Young?
Family court is fertile ground for predicate orders. In each of the above state court actions, dependency, delinquency, our whole list, there is an opportunity there's a double-sided opportunity to secure stability for a child. Not only the immediate relief on the state filing, for example, a child gets a guardian or safe placement, but there's also the opportunity to establish a basis for a predicate order, such as we're going to address in most of these issues the possibility of the finding of abuse, neglect, abandonment. It's going to require the court to determine a child's placement, and it's also going to require the court to determine whether or not it's feasible for reunification. State courts regularly make care and custody determinations. This is the normal, everyday purpose of a family court. We're trained and experienced in these areas. Federal law recognizes this. That's why SIJS is set up in a two-tier process, with the state court making these best interest determinations.
And so,
Leslie?
Yeah, thank you. And so, where the state court order, those of you that may have been familiar with these cases, there was a major change in the law in 2008. Prior to 2008, to get an SIJS order, a child had to be essentially in foster care. And in 2008, Congress totally restructured the law and opened up special immigrant juvenile status and the opportunity to obtain predicate orders to a child anytime that a court issues any kind of an order, and all those different proceedings that you saw a moment ago regarding the care, custody, or placement of a child. And it could be placement with an individual, so it could be with the other parent, it could be a next friend, a guardian, it could be with a state agency, or it could be with a private agency. And so the other thing that's really important, a major change in the law, is that only one parent has to have perpetrated the abuse, abandonment, or neglect. So a child can qualify for special immigrant juvenile status when they're with a protective parent or a non-abusive parent, or they've been placed with their battered immigrant parent or a battered parent who's still caring for them. Now, in Oregon, as in many other states, when you have a one-parent case, meaning you have a protective parent who's coming to court and seeking these orders, custody or guardianship, or they're an abuse and neglect case, etc. In Oregon, they wouldn't be an abuse and neglect case if they're with a protective parent under the case law, if the child isn't in any risk, so that they would need to find another avenue into court, which is why the various different kinds of court proceedings are much broader. So if child abuse and abandonment the child abuse proceeding isn't an option because they're living with a protective parent, they may come under guardianship, they may come in under a custody case, as opposed to the abuse and neglect case. So it's just important to note that. And the other thing that's important to note, when Commissioner Young was talking about one of the findings being that reunification is not viable with the parent who perpetrated the abuse, abandonment, and neglect, it's really important, and there's very good case law nationally on this, that including a Supreme Court decision from New Jersey that came out a few months ago, that make it really clear that viability of reunification is only with one of the child's parents, and it's not viable due to abuse, abandonment, or neglect, and that there's a difference between termination of parental rights and viability determination. So you don't have to have found termination of parental rights that would be under your state law, this is a lower standard in terms of the viability, and it's viability of reunification in terms of what's the placement where the child is going to be in the care of an adult until they turn the age of majority. And so best practices for findings in these cases is to make findings of fact about the abuse, abandonment, neglect, vis-a-vis the abuse, each parent who is involved in perpetrating the abuse or abandonment or neglect. And to be specific, what won't work for the Department of Homeland Security is if you say the child was abused, abandoned, or neglected. They want to know what you found, what the court has found, which one of those it was and based on what facts. And I'll just note, there may be cases where you, for safety of the child reasons, may need to have your findings under seal, in which case the order that you're providing in terms of the predicate order would say, I heard 6 or 7 witnesses, had a 2-day trial on this case, have adjudicated, have found that this child is abused, giving them some details about the kinds of proceedings you held so that they can see that this is a considered order in the child's best interest, even if the actual facts are under seal. It's important when you're issuing your predicate orders to cite the state law that you're relying upon, because then Department of Homeland Security isn't going to necessarily know that. And if you're using similar basis, you're going to have to make findings as to why that state law is similar to abuse, abandonment, or neglect. And those cases are a bit more complex. It's often easier or better if you can stay within the definitions of abuse, abandonment, and neglect under your state law. Commissioner Young?
As Leslie just talked about, we don't have to reach the standard for termination of parental rights. So a state court can still find that reunification is not viable, even if the parent is receiving reunification services. You're looking at asking that state court to decide at that moment whether reunification is possible.
Right, and what's important to understand is Congress, as you look at the evolution of these statutes, what they did was originally they required that children be committed. Then they said, no, not committed. We're going to make it more, we're going to open it up to more children by saying, no, they only need to be eligible for foster care. And then they said, well, they recognized that children, you could make that determination, but the children's needs may change and circumstances may change over time, and they wanted to have that flexibility. And so they moved to a situation of this determination of reunification and viability as opposed to the commitment structure from before. And so they recognize none of us have a crystal ball here, and courts are always checking in and intervening to make sure that different decisions are working for that child. So it doesn't preclude a different, let's say, change of placement later on, and but that you don't have to. But there is some flexibility in the standard, and it's about what you're perceiving based on the facts before you at the time, in terms of what you envision in terms of viability of reunification. Commissioner Young?
When you are seeking a finding that it is not in your client's best interest to return to the child's home country or the parent's home country, this is a fact-finding mission for the Immigrant Child Council. The court needs and wants to hear the factual basis for your argument, and it should also be recited in the proposed order and findings for later use. The best practice would include identifying potential placements both in the U.S. and the home country and analyzing the benefits versus the detriments. So going through a best interest analysis. Detail for the court the nature and duration of the abuse and by whom it was committed. And keep in mind that a lot of states have statutory presumptions. For example, Delaware has a presumption that if someone has committed domestic violence, that they should not have custody of a child. You might also want to detail for the court long-term and short-term effects that this abuse has had on your client. And if there is a potential placement outside of the U.S., then you need to go into country conditions.
And what, go ahead. And what the country conditions mean is if in fact, let's say there was a grandmother in the home country and a parent, one of the parents here, or a guardian or an aunt in the United States, what you're going to look at is, first of all, whether that grandmother was involved in the abuse, abandonment, or neglect at all. And you also want to look at the risk where the child's health and well-being will be better. If that grandmother lives in a community ridden by gang violence, then that's going to be part of your comparison with where they might be living in Oregon or in Delaware or in the United States and who would be caring for them. And you're going to do it in addition to looking at caregivers, looking at a comparison and making and discerning using the best interests of your the best interest statute in your state, which location, the United States or the home country, is in the best interest of the child. And so, and that best interest finding, to the extent the court works with other administrative or judicial officials who may make recommendations to the court, and then the court makes, let's say, a final custody determination based on those recommendations. If the court is authorized those findings or recognizes them part of the order, they are sufficient if they include the predicate findings for SIJS purposes. As I mentioned earlier, there have been major changes in the law in 2005 and 2008. In 2005, the other change that was made as part of the Violence Against Women Act is there used to be a practice in which the Department of Homeland Security would go and try to track down the abusive, they would either track down or force the child to try to track down their parent who had abused, abandoned, or neglected them. And the Violence Against Women Act in 2005 cut off the ability of the Department of Homeland Security to kind of force that process as part of these adjudications. So it's no longer required. And the other thing to be aware of that's really important is that in this area of immigration law, like many, you have an old statute that was revised several times by Congress. After the first statute was written in 1990, there were federal regulations written in 93. And if you as lawyers or you as judges send your law clerks to go look up the regulations today, what you'll find is that the regulations have been overruled twice by statute, in 2005 and then again in 2008, and there's no new set of regulations issued yet. That is common practice unfortunately, in immigration law. It takes time for the regulations to come out, and so it's really important to not get confused by the regulations and to make sure that anything you're doing on SIJS is governed by the statutes. Commissioner Young?
In SIJS cases, keep in mind that state law will govern a lot of the definitions. For example, age of majority is often 18, not 21, as it would be in federal jurisdiction. And so you have to be mindful that your client may age out. The definition of abuse, abandonment, neglect, the state definition controls when you're pursuing the predicate order. Family court jurisdiction, and you also have to follow your state law regarding service of process and family court jurisdiction. And I know that this jurisdiction can be troublesome in some states, particularly Oregon. I noticed that Oregon does not like to accept custody cases where the child lives with a petitioner parent and the pleading does not allege likelihood of harm or welfare to the welfare of the child, or it pleads speculative harm. So in this particular cases where you're looking for that predicate order, your child is living with a non-abusive parent, and you're thinking that you want to file a custody petition, but the court is not going to take jurisdiction because of the established case law, you're going to have to develop your facts. So maybe you can plead things like, this child, it's important for parent to obtain a sole custody order because for purposes of school admission, or there may be other program requirements, health care benefits. Maybe if your child is older, he or she will not be eligible for in-state college tuition and may not be able to afford certain school because of that. So you may have to develop your facts, or as Leslie said earlier, maybe that's just not the petition that you need to come in under.
Right, and so you want to look carefully at, what are the rules regarding the child abuse cases and how they differ in your state from the custody cases, from a guardianship case, from a declaratory judgment case. And that's partially why all of those are potential avenues in these cases. And what's really important, too, is that you're also in these cases applying the state law definition of abuse, abandonment, and neglect to events that occurred in the United States if the abuse, abandonment, or neglect occurred in the United States, but also if the abuse, abandonment, or neglect occurred abroad, it's the Oregon or Delaware or Washington State, wherever you're located, definition of abuse that applies to the facts that occurred in India or El Salvador or Mexico or Guatemala. So it's important to you're within the same realm of the statutes that govern that you and the case law interpreting those statutes that you are in any other case, but you're applying them sometimes to facts outside of the jurisdiction. Commissioner Young?
Council will want to ensure that the state court order satisfies the federal requirements. You want to, as I said earlier, plead with particularity. That's what you're pleading is like the backdrop, and do it with particularity and richness. So state the full and relevant factual basis, lay out for the court, and so that you can use it in that immediate proceeding, and so that it can be carried forward as evidence in your client's immigration proceeding. Cite the state law and statutes, attach legal memo or ask permission to submit. Don't waive your opening, because this can be educational for the judge. But remember, though, the feds are not going to pull your transcripts. This is just for your judge. Submit a form of order containing what you established at the state hearing and what you need for the predicate order. Keep in mind that not all judges have immigration training. Dockets are heavy. They have time constraints and that may prevent them from a full review of your file. But law clerks, if you submit legal memorandum, law clerks will digest that and review it with the judge prior to the hearing. Ensure that the order articulates the facts. As discussed before, take advantage of every opportunity to educate the court and plead your case. And the next slide, I think, goes a little further into detail with this, of how you need to, it's all about the details. So don't just state in there that the child's dependent on the court. Tell the court how the child is dependent, why someone else should be getting custody of this child. Connect the statutory law with your case. You can't just parrot back the federal standards. You have to tie it to the facts in your own case.
Right, so that, for example, the child cannot be reunited with their biological father due to the abuse caused, and then you by him, and you describe the abuse that caused and cite the statute, as opposed to saying the child was abused or abandoned or neglected, and the USCIS can't tell whether you're just quoting the immigration statute or what actually happened, what the court is finding specifically regarding that child.
Yes, you have to just to avoid general statements of law. SIJS in state courts. This notion of parens patriae underlies every family court proceeding. The court has a duty and a role to provide both protection and guidance to the children who appear before it. It follows that the court should consider SIJS just as it would consider various other options that lie beyond the front door of family court. We further children's best interests by recognizing SIJS opportunities. So judges can be vigilant and look for clues that this may be an issue. Look at the separate, and counsel also, look at the custody separate statement. I don't know what that looks like in your state, but in my state, when you file any kind of proceeding in family court involving a request to change placement of a child, you have to detail where this child was born, where this child lived. So you can gather a lot of information from there. You may have a birth certificate. There may be another file that has child support information in it. So a judge should explore the file, and also you can certainly ask questions of the litigant to draw out relevant information.
And what's really good about doing that is to the extent that it becomes more standard practice when a court sees that there's a foreign-born child coming before the court, if they are identifying this potential for SIJS earlier, or at least asking counsel to identifying and asking counsel to, whether they've explored it and would report back to the court about whether they want to consider that, et cetera, then the kids that are coming before the court, the children that are coming, foreign-born children that are coming before the court for custody, for protection order, for child abuse cases, as a matter of course, they will be able to get that remedy before they actually age out of the state's jurisdiction. And that's really key, because in most states, the state court lose jurisdiction over a minor when they turn 18, and which is why courts are seeing kids coming in at 16 and 17 years old trying to get these orders before they turn age 18. And that could essentially prevent that. Some states also have ways to exert continued jurisdiction over a child. I know after the age of 18 and before the age of 21, like the adult adoption statute in Oregon, or some states have continuing child support jurisdiction under certain circumstances. So those may be considered, but it's always better to try to get these orders before the child turns 18. Commissioner Young?
Again, subject matter, personal jurisdiction, service of process, whether that is required to be hand-to-hand, publication, certified mail, or whether or not you need to notify the consulate. These are matters that are all determined by your state law, and you need to be cognizant of that.
And one thing that's really important about consular notification here is that the consular notification can play a really important role in terms of the child in some of these cases, because they can help pay for things like they can pay for counsel. They can weigh in various different ways to help the child that I think it's important for courts and counsel to be aware of.
Where parties may live in two different states or two different countries, you may look to the UCCJEA for guidance regarding jurisdiction. So a home state would be where the child has lived and a foreign country within the last 6 months. And the foreign country also counts as a home state. However, in emergency situations, the court may also exercise jurisdiction where it is alleged that the child is present in that state and being abused, abandoned, or neglected.
So the other thing that's important to know, and Oregon is one of many states that has declaratory judgments, is that there are certain kinds of cases where the declaratory judgment may be the best option, that the court identifies for how the case proceeds, or that counsel identifies. And key examples of that are there are some children that might be in federal custody where the agency that they're placed with won't bring the child to court to get the predicate orders before they're turning the age of 18. And so there's no real need to change the placement of the child because they're in federal foster care or federal custody. And so a declaratory judgment would be an opportunity for the court to make the predicate orders without changing the placement. Another example might be where the court has been involved in issuing protection orders or child abuse rulings, or there's been a contested custody case that might be domestic violence related, where the court has already issued lots of orders regarding these children, and either because they weren't asked, or the judge hadn't had the training or didn't know about this kind of case, didn't take the opportunity to issue the predicate orders at that time. You could use a declaratory judgment to kind of bring those all together, talk about how the court has been involved in orders affecting the care, custody, and care and custody of this child and placement, and then add the predicate orders that way. So there's a variety of different ways to do that that are, I think, important.
The beauty of filing a motion for declaratory judgment is just that. It is a motion. So motion practice applies. That means it can be decided on the paper. You can spare your client the trauma of testifying. You can shorten the hearing, use it in all the situations Leslie talked about. It can be scheduled sooner, and there are different notice requirements that can be significantly less burdensome.
And so we talked already about the best interest of the child and the factors in terms of comparing the country. So best interest applies in various cases here. It applies to the country comparison and the placement of the child and the viability of reunification. And that it is helpful to courts to provide evidence, to make findings of these kind of country conditions. Go ahead.
Best interest under state law is just very simply contrasting the advantages of your client's present situation with the mistreatment that he or she either previously experienced or would face in the future if, to demonstrate that the current situation best serves the child's interest. As we talked about, the range of court orders are pretty wide that you can use as a predicate order. You might want to consider some trauma-informed ways of obtaining information from your client. So you're going to have to get some facts from your client about the abuse, abandonment, or neglect. And you have to also think that your client might have to testify about that in court. Some of the easier ways to do that from a trauma-informed approach would be having your child assigned a child advocate or a CASA, getting your child connected with a therapist who could also testify in court, taking your child to a child advocacy center where they have forensic interviewers, and usually they're available whenever there's been child abuse or maltreatment. And it can be taped, and under some state statutes, you may be able to use the tape instead of having your child testify live. You should also think about how to get information from or testimony from your client in a more trauma-informed way. A lot of judges will let kids sit in any seat in the courtroom so that they're not on the witness stand and being stared at. They can testify in chambers, but still on the record. Sometimes the judge will take their robe off, put the child in a position of equal elevation, so not necessarily the judge sitting up high. The judge may come and sit at a table with the child. They may allow an adult friend or a victim advocate in the courtroom and allow a child to hold comfort items such as pillows or stuffed animals.
So the last two things we're going to talk about as that we want to be sure to highlight in this is that when a child applies for special immigrant juvenile status, not only do they have to qualify for the status, but they have to ultimately be eligible to attain lawful permanent residency. And there's certain factors that would normally bar access to lawful permanent residency that don't apply in cases of special immigrant juvenile status. And this slide lists some of the more common ones. However, there are other kinds of offenses. Commissioner Young?
I'm going to summarize both the waivable and non-waivable slides together. The thing to remember about juvenile adjudications is that they are not convictions for purposes of immigration, and they do not carry the same immigration consequences as convictions in adult courts. Nonetheless, many juvenile adjudications can trigger conduct-based grounds of inadmissibility, such as if your client admits to something that may give the federal agency reason to believe the child's been involved in drug trafficking, gang involvement, or that there is drug addiction or drug abuse. And so therefore you have to be aware about entry into drug court programs. You also have to be careful if your child sometimes there are certain offenses where they're charged as an adult, but if you can talk to the prosecutor and plead to a lesser included and ask to be heard, have that tried as a juvenile, that may be more beneficial because you definitely want to avoid adult convictions.
Commissioner Young?
SIJS eligibility. Obviously, you don't want to stereotype in order to identify SIJS issues, but as I said earlier, search the file, develop protocol in your office for identification, a line of further questioning that's not intimidating and that will encourage cooperation.
And it's also an opportunity for courthouses to, like, there is materials that can be available about legal rights that are available in brochure form at courthouses, etc. Making the information available about SIJS at the courthouse could be another way of letting counsel, the public, and others know that these remedies are available and that the state courts have a role to play. So I'm going to, just before we open it for questions, I want to summarize. So what does a child receive when they are eligible for and begin applying for special immigrant juvenile status? Once they receive a predicate order and file their case with the Department of Homeland Security, children receive protection from deportation and removal, so it stops a case against them potentially from going forward. They're considered lawfully present once the SIJS case is filed for purposes of purchasing health care through the health care exchanges. There's no subsidies available to them, and whether or not their subsidies would be dependent on the state. And then, and we have a state-by-state map on the new app website where you can look up what lawfully present children are eligible for and that they can receive state by state. They can get educational benefits, and they're eligible for programs, educational, certainly in terms of elementary and secondary schools, etc. And then there are programs and services necessary to protect life and safety that they're eligible for. Once their case is approved and they file for lawful permanent residency, they get legal work authorization, they're eligible for citizenship in 5 years, they become eligible for post-secondary educational college grants and loans, public and assisted housing, food stamps until they turn the age of 19, but they may never file a family-based petition for either of their national parents, including a parent who was the protective parent. So they can't sponsor either the abusive parent or the protective parent.
We have technical assistance available. There's materials available on our website. We encourage you all to look at those materials and call us with further questions. Questions that we didn't have a chance to enter. There were a lot of good questions during the webinar that we didn't get a chance to answer live. We will do in a Q&A format that will be posted along with this webinar presentation on the web. And again, thank you very much for attending. If you have further questions, please don't hesitate to call us. And thank you for joining us.
Thanks everyone for joining today's web conference. You will be receiving an email confirming that you attended today's session along with a link for the materials and an evaluation of today's session. Please follow through. Thanks to all of our speakers today, and thank all of you for participating. This concludes today's New App webinar. Thank you, and we look forward to seeing you in a future New App webinar.
Thank you.